We good? All right, thank you. We're back on the record now. So no action was taken in the executive session except when we, or not, except when we had a motion to extend, which was at 2:48, unanimous motion to extend to 3:30. So yes, thank you. Also then consistent with AMC 2.30.036C, is there a motion regarding when to disclose the record of the executive session? Ms. Zalato.
Yes, pursuant to 2.30.036C, subsection 1, I move that the tape shall be disclosed when all causes of action have been resolved by final judgment or when further claims arising from the matter are otherwise barred.
Second.
So, okay, the attorneys think a different motion is appropriate. So we have the motion and the second. Seconded by Ms. Brawley, moved by myself.
So I spoke with the municipal attorney prior to making the motion. The issue of it just being covered by attorney-client privilege is not currently in code. It is something we have identified as not currently existing in code.
Okay, so then the answer is, what I would offer is that the release of the tapes is allowed subject to privilege. And so any privilege that might exist is still in existence and thus must be sorted through by the recipients of the request. Okay, so is it fair amendment to your motion?
Sure, it's inherent in
Right.
every item where we choose to disclose the tapes or when the tapes become available for disclosure, attorney-client privilege information can be withheld similar to any other privilege that may apply.
Okay, thank you. So the motion is to disclose when all legal matters are resolved pending any privileges. So go ahead.
Just very briefly, since I've been on the body, I think that has been consistent that we have discussed that these are public records, but there are these legal issues. And so the idea of forever sealing public records under all circumstances gives me heartburn personally. And so that's why I support understanding that these are legal considerations. Thanks.
Thank you. Any further discussion? Like ask unanimous consent on the motion. Any objection on the phone? Hearing no objections, the motion is approved. So next we have back on our agenda, item 4A. Item 4A is AR 2024-309, a resolution of the Anchorage Assembly appropriating $250,000 for settlement of Amy DeVosky's claims against the municipality of Anchorage. Also subordinate to that is laid on the table memorandum, which is from the mayor, a resolution of the Anchorage Assembly appropriating an amount not to exceed $250,000 of area-wide general fund 101 fund balance to the office of the municipal manager to pay the settlement of Amy DeVosky's claims against the municipality of Anchorage. So we need a motion. We have an S version for this item. Yeah, so the one that
Move to
was handed
approve the S.
The motion to
Second.
approve by Ms. Zalato. Who's the second? Mr. Prisverdia? All right, any discussion? Ms. Zalato.
Thanks. I just have a question. Looking at the AM and the fund certification, it shows that this will initially be paid out of fund balance, and then in the following tax year, it'll be taxed above the cap, is my understanding, and then the fund balance will be repaid. Is that a correct understanding of how that will function?
That is my understanding from OMB.
I would offer, I think it's in the document as well. It states it's collected above the cap. Yep. Okay, any discussion on the item? So with that, members may proceed to vote. Madam Clerk, may I call the roll?
Member Presverdia,
Yes.
Member Solt,
No.
Member Brawley,
No.
Member Bronga,
No.
Member Zalatel,
Yes.
Member Constant,
Yes.
Member Rivera,
No.
Member Littlefield,
No.
Member Martinez,
No.
Member Myers.
Yes.
Member Myers, that was a yes.
Yes, correct.
Thank you. The motion fails 4 yeses and 6 nos.
4 to 6.
Correct.
All right, on a vote of 4-6, the motion has failed to pass. Next, we have item 4B on the agenda. Item 4B, which is information memorandum 154-2024, legal and financial settlements paid by the administration resolving claims against municipality, its officials and employees. Is there a motion?
Move to accept, or is it?
Yep.
Second.
Okay.
Motion is to accept, Ms. Alatal, second, Ms. Brawley. And any discussion? Hearing seen none, members may proceed to vote.
Oh, boy. Member Martinez,
Yes.
Member Littlefield,
Yes.
Member Rivera,
Yes.
Member Constant,
Yes.
Member Zalatel,
Yes.
Member Bronca,
Yes.
Member Brawley, Member Salt,
Yes.
Member Presverdia,
Yes.
Member Myers.
Yes.
The motion passes 10-0.
All right, on a vote of 10-0, the AIM has passed or has been accepted. So next we move to audience participation. Any member of the public wish to be heard? Anyone at all? Seeing, hearing none, we'll now move on to member comments. Mr. Salt.
No, thank you. Have a good weekend.
Thank you. Mr. Littlefield,
No comments, Chair. Thank you.
Mr. Presverdia,
No comments. Thank you.
Ms. Bronga,
No comments?
Ms. Brawley,
No comment.
Mr. Martinez on the phone.
No comment. Thank you.
You, Mr. Myers.
No comment. Thank you, Chair.
Thank you, Mr. Rivera.
No comment, Mr. Chair.
Thank you, Ms. Alatal.
Thank you, Mr. Chair. So I regret not debating that item for A. I think it is a mistake to reject a settlement when the parties are done with litigation. When you're done, you're done. Litigation is hard for both sides. I also think if the no votes were because we think we're going to learn something more, I think that's a misguided idea of what litigation brings. Litigation ultimately are carefully crafted narratives to try to win your argument. And I think that it is unfortunate that we can't let mutually agree upon litigants settle a case when they are ready to settle. I previously, when this came before us and everyone was ready to settle, I said we should settle then as well. And so I really would ask members who voted against settlement of this case to think long and hard about why and what you hope to obtain out of not letting two parties who want to be done with litigation walk away under terms that they agree upon. Thank you.
So I don't have anything to add. Everybody have a good weekend, and we'll probably find ourselves back here dealing with the Domboski case at some point in the future. Thank you, everybody, for a thoughtful conversation about our legal strategy. We're adjourned.